Stephen Koprince, Managing Partner of Koprince Law, LLC. Today I'm talking about an interesting Armed Services Board of Contract Appeals decision that helps us understand what happens when a contractor asks the government to terminate his contract for default. In its decision, the ASBCA held that an agency had improperly terminated a contractor for default merely because the contractor requested that the government cancel its contract. Now, it's not terribly unusual for a contractor to request that its contract be terminated. If you think about it, this typically happens when the contractor realizes after it was awarded the contract that it made a mistake in its bid or that some changed circumstances outside of its control typically will result in the contractor being forced to perform the contractor at a loss. And that seems to be what happened in this case. It's a case called Cappy Machine Shop, Inc. The Armed Services Board of Contract Appeals docket information, if you want to look it up for yourself, is 59133. Now in that contract, the DLA awarded a contract to Cappy Machine Shop for the supply of 27 splice fairings. But after award, Cappy's subcontractor amended its own quotation to Cappy to include an additional one-time charge of $26,512. And that charge had not been incorporated in Cappy's original proposal to the DLA. So Cappy's now apparently concerned that it's going to have to perform this contract at a loss. And Cappy emailed the contracting officer and said, and I quote, "Please cancel the above contract at no cost to Cappy Machine." Well, instead of canceling the contract or really responding substantively to Cappy's email, the DLA issued a show cause notice asking Cappy to explain why its contract should not be terminated for default. And in response, Cappy explained that it had requested the cancellation because of the subcontractor's new charge. Now that explanation apparently didn't satisfy the DLA, which ended up terminating the contract for default. And Cappy appealed that default decision to the ASBCA. At the Armed Services Board of Contract Appeals, the DLA argued in part that the default termination was justified because Cappy had anticipatorily repudiated the contract. That's a fancy term that means that Cappy had taken some action that demonstrated that Cappy had no intention of performing the contract. And in the DLA's view, that action was its request for cancellation. By requesting cancellation, the DLA said just merely by requesting cancellation, Cappy had demonstrated that it had no intention of performing the contract. Well, the ASBCA started its analysis by reiterating a long-standing rule that a default termination is a drastic sanction, which should only be imposed, in the ASBCA's words, for good grounds and on solid evidence. Now in this case, the ASBCA held Cappy's request for cancellation did not constitute, and again the ASBCA's words here, a positive, definitive, unconditional, and unequivocal refusal to perform the contract. And the ASBCA said that's what would be needed to show that Cappy had anticipatorily repudiated the contract. A positive, definite, unconditional, and unequivocal refusal to perform. Now instead, the ASBCA wrote, Cappy made a request to which the government never really responded except to terminate for default. And I think that's a fair statement of what happened in this case. And the ASBCA granted Cappy's appeal and converted the termination for default to a termination for convenience. If a contractor finds itself in Cappy's position, staring at the possibility of performing a contract at a loss, it's not unusual, as I said, for the contractor to request that the contract be canceled. Perhaps at no cost, and often a no-cost cancellation is what the contractor requests, understanding that if the procuring agency does cancel at the contractor's request, it's unlikely to want to foot the bill for doing that. Well, as the Cappy Machine Shop case demonstrates, a mere request for cancellation, including a no-cost cancellation such as what Cappy requested, standing alone at least, does not mean that the contractor is repudiating the contract and should not justify a default termination.